I'm attorney Louis Haskell at the Hoi Dong Tao Reservoir in beautiful Chiang Mai, Thailand. And as sometimes happens when I travel, the government actually does something that is good for my clients. I've actually done videos from this spot previously, and this one is regarding the new guidelines concerning the settling or discharge of student loan debt in bankruptcy. This past week, the Department of Justice and the Department of Education jointly announced new and much more objective guidelines for when a student loan can be discharged in bankruptcy. This creates an exciting opportunity for a large number of people who have significant student debt and cannot pay it back. I mentioned that it was more objective. Although in Massachusetts we're not subject to the Brunner standard, we might as well be, and thus we are subject to a standard of the debtor having a certainty of hopelessness, whatever that means, in order to discharge a student loan. Now we have adopted the three-prong test that's associated with Brunner, but have come up with clearer definitions of what it means. The first prong, of course, has to do with whether or not the debtor is capable of paying their debt. Under the new guidelines, we simply look at the IRS tables for their collection standards, and we see if this person were subject to tax collection, would they be able to pay that? And if the answer is no, then they also can't pay their student loans. The good news is that in bankruptcy, we've been working with these IRS tables for a number of years. We use these tables to determine whether or not so-called high-income debtors, people with above median income, can file for Chapter 7, or if not, how much they have to pay in Chapter 13. For the most part, people who are below median are going to find that these tables say they cannot pay. So where under the old standard we were never sure whether or not they could pay or they can't pay, now we have a nice objective standard which most people in bankruptcy will be able to meet. More importantly, we continue to use these IRS standards for the second prong, which has to do with ability to pay in the future. And still more importantly, we do not look at the lifetime of the debtor, but rather the term of the loan. Now, most federal student loans have a 10-year term, and most people in bankruptcy have already probably used up those 10 years or soon shall. As such, we're not looking out over 10, 20, 30, 40, 50 years to determine whether or not a debtor may possibly have the ability to pay debt at some point in the future, but instead we're looking at a more foreseeable timeline. And especially for people who are at or near the 10 years, or well beyond it, the real question becomes, if we've already passed the first prong, is there a likelihood of a significant financial change in this rather foreseeable future? As such, most people who are in bankruptcy and have passed the first prong are likely to pass the second prong as well. We also have certain presumptions that are built into the new standard. People who are over 65, people who have disability, people who have 5 years or more of unemployment in the last 10 years are all presumed to be unable to pay this debt going forward. The third prong has to do with good faith, and it specifically addresses the issue of income-driven repayment plans. Under the old standard, income-driven repayment plans kind of presented a damned if you do, damned if you don't standard. In other words, the government was arguing successfully that a debtor in an income-driven repayment plan was not experiencing an undue hardship because they're in this plan. Sometimes this plan required a payment of zero, but in any event, the payment on the plan was something that was deemed to be affordable by the debtor and certainly not an undue hardship. However, these guidelines changed the standard And instead of an income-driven repayment plan being a grounds for denying a discharge, entering into an income-driven repayment plan is now evidence of good faith on the part of the debtor. Similarly, there's an argument made that not entering into an income-driven repayment plan is evidence of bad faith. However, the new guidelines acknowledge that the income-driven repayment plan system has frankly been an abject failure, that there's been a lot of problems with it, and that there are a lot of good reasons why a person who owns student loan debt might opt not to enter into an income-driven repayment plan, and the guidelines suggest several. And so, if the debtor can attest to the fact that one of these reasons applies to them, then we've overcome the idea that not entering into an income-driven repayment plan is evidence of bad faith. So as a result, we have this new standard. It is new. It has to be implemented. We have to study this and look into it and look forward to working with clients to get them out from under what has historically been very burdensome and yet non-dischargeable student debt. I look forward to working with many of you in the future. Thank you.